Hi everyone, we're Group 5. Today, we will be presenting the case Law Society of New South Wales v. Foreman, decided in 1994. First, I'm going to talk about the case facts and ruling. This case started as a cost dispute between a family law solicitor, as Clayton Oates, and her clients. The key question was whether a no-scale cost agreement had been given to the clients. To support her position, the solicitor rewrote and swapped a page from the firm's 1989 timesheets. So it looks like it was written on the day. She then included that edited page in affidavit of discovery and let it be produced to the firm court. How was this discovered? The firm's account team had kept photocopies of the original timesheets. When they compared the copies to the page used the court's materials, the difference was obvious. So the alteration came to light, and the matter was referred for discipline. At first instance, the Legal Profession Disciplinary Tribunal found professional misconduct. It imposed a 20,000 fine. That tells us the tribunal treated the conduct as serious, but it still left the solicitor on the roll. On appeal, the New South Wales Court of Appeal went further. The court ordered that the solicitor's name be removed from the roll. The judge stressed that the removal is protective, not punitive. In other words, the aim isn't to punish the person for the sake of punishment. The aim is to protect the public and maintain confidence in the legal profession. The court focused on whether the solicitor remains a fit and proper person to protect it. Honoring a document and putting it before a court strikes at the heart of honest and candor, values that the courts and the public must be able to rely on. Because of that, the court decided that a fine was not enough. Removal was necessary to protect the system and the community. So the takeaway is simple. In a court dispute, you must still be truthful. If a lawyer alters evidence or misleads the court, the likely outcome isn't just a fine. It may be removal from the role because our system depends on trust. This concludes the case facts and ruling. I will now invite Julie and Sheila to walk us through the right decision.
To understand why an experienced solicitor like Carl Foreman fell into such a misconduct, we can reverse engineer this case using REST-4 complement model of moral behavior. This model examines 4 stages necessary for ethical action, including moral sensitivity, moral judgment, moral motivation, and moral character. Firstly, we will look at the moral sensitivity stage. Given Foreman's experience and professional standing, she should have recognized the ethical dimensions of her conduct. An ethical lawyer would immediately see that falsifying document and misleading the court was a significant ethical breach, not merely a technical issue. However, Foreman's testimony reveals her failure of moral sensitivity. When asked in court if she considered what she was doing and the consequence, she answered, "No, none whatsoever. Had I given a moment's thought, I would not have done it." She also admits she gave no thought to whether the family court would be misled. This testimony shows Foreman failed to recognize the nature of what she was doing and didn't support the ethical issue. But why did Foreman's moral radar fail? The case hints two influencing factors. The first one was management stress. Clayton was closing the family law division, meaning Foreman could be forced to leave the firm and possibly never practice family law again, a profession she loved and took great pride in. Secondly, this pressure pushed Foreman into what she described as an irrational state characterized by panic and amnesia. She claimed she was close to breakdown and receiving medical treatment at that time. Foreman testified she revolved the timesheet in total irrationality and didn't remember doing it. These two factors, external management pressure and her inner physiological state, work together to severely diminish her moral sensitivity. The second stage is moral judgment. Even if a person spots an ethical issue, they need good moral judgment to decide what's right. Although this case occurred in 1994, here we assume the current law applies. Under current NSW legal standards, solicitors have a paramount duty to the court, must not deceive or mislead the court, and must act with honesty and integrity. Foreman's conduct clearly breached these standards. Despite claiming she didn't remember the incident, Justice Giles found, even though she didn't remember what she had done, she knew she had done wrong. This suggests Foreman possessed the capacity for moral judgment, but failed to act accordingly. She understood what was right, but didn't follow through. Foreman also misapplied legal standard and rationalized her wrongdoing. Falsifying the timesheet and producing it to the court was misleading conduct that violated her paramount duty to the court and the requirement for honesty and integrity. Despite having ample opportunity, Foreman failed to correct the misleading document, violating her duty to take necessary steps to correct false statements. Someone showed the pattern of rationalization. Instead of acknowledging I'm lying, she likely reframed it as correcting the record or fixing a mistake. Her testimony confirmed this. When I saw them, the writing was different, so I wrote the writing to be the same, which treating falsification as merely make documents consistent.
Now we'll talk about the moral motivations. Foreman's moral motive collapsed because she fails to uphold honesty and professional responsibility when faced with self-interest and work pressures. As Judge Mahoney points out, her falsification of the timesheet was elaborate and calculated, knowing it would be mislead the court, motivated by a desire to secure her position in a legal court dispute. Although Foreman may have known that falsifying records will breach the legal profession at the time, she rationalized this deception as a self-protective measure under war and budget pressures. The moral freeze caused by this high pressure led her to prioritize self-preservation over the moral value, resulting in a failure of moral motivations. Therefore, the Foreman's dilemma lies in the fact that she may know the correct code of conduct, but lack the moral will to practice. Her failure of moral motive reflects that her professional value were replaced by survival instinct, which means protecting her position and reputation replaced honesty and integrity. Then we will talk about the moral character. First, the Foreman failed to demonstrate the candor and remorse expected of legal profession when facing the Law Society investigation. The court noted that she adopted a persistent defensive stand, attempting to rationalize her action rather than directly and fully acknowledging her misconduct and taking responsibility. This pattern of behavior indicates that even after her misconduct was discovered, she lacked sufficient moral courage to confront her serious faults and failed to proactively engage in deep and public self-criticism. Moral character demands precisely the courage and integrity to admit wrongdoing, take full responsibility, and take concrete remedial measure after making the mistake, and she failed in this aspect. Exactly, the Judge Mahoney raised a thought-provoking concerns. Even if the likelihood of Foreman falsifying document again in the future is low, the court worried that she might still engage in other unethical behavior under the immense pressure and predicament. The judgment concern indicate that Foreman's problem lies not only in a single instance of misconduct, but also in a fragility of her inherent moral character, leading to a lack of self-discipline and moral fortitude necessary to consistently uphold correct conduct in a complex and high-pressure professional environment. Then we will move to the MEDI to talk about enable and disable.
My part examines the enablers and disablers at three different levels. Foreman's ethical lapse began at the stage of recognition and reasoning. When faced with a cost dispute, she lost moral awareness under stress, exhaustion, and fear of losing her position. Instead of viewing the missing file note as a potential ethical problem, she rationalized it as simple reconstruction, convincing herself she was fixing an administrative error. At the firm level, billing targets and the threat of closing the division intensified that pressure. Ethical guidance and separation were absent. As Kirby P. observed, commercial imperatives had distorted professional judgment. Limited ethics education in the 1990s also left practitioners without practical direction on how to act in such a situation. The next two slides look more closely at the professional enablers that should have guided Foreman's reasoning. The key practice rules operate as formal enablers of ethical behavior. The solicitor's paramount duty to the court, together with the requirements of honesty, integrity, and independence, and frankness in court, articulate the profession's legal expectations. And the common law has long defined these standards. In Myers, the House of Lords held that a solicitor bears personal responsibility for honesty and diligence in discovery. Kirby P. cited to stress that the courts must be able to rely on what a solicitor says. In Hawkins, the court described the standard of care as qualified, competent, and careful solicitor. These precedents already provided clear professional enablers. In Foreman, these standards failed. She omitted a final recording the cost agreement, showing a lack of diligence and care expected of a qualified and careful solicitor, and later falsified internal timesheets and produced them to the court, knowing they were false, breaching the duties required by case law. Moral motivation depends on how a solicitor ranks competing duties. At the moral motivation stage, Foreman's very hierarchy collapsed. Her primary motive was personal and defensive. Fear of blame and loss of status outweighed honesty. A strong professional identity would have reminded her that a solicitor's first loyalty is to court. At the professional level, adversarial success norms and reactive regulation reduce the motivation force of integrity in workplace. This reflects a cultural feature of common law practice where lawyers' effectiveness is measured by winning for the client or firm rather than fidelity to duties like candor or justice. This is typically described as raw morality, the belief that a lawyer's moral responsibility ends once they act within the law and zealously advance their clients' or firm's interests. Foreman's misconduct arose in a culture where commercial goals eclipsed ethical reflection. The forged note wasn't created in a vacuum. It came from a firm environment driven by cost recovery and performance metrics. Kirby Peace remarked, recognize that the profession's structure itself has become distorted by money and competition to some extent. A solicitor's worth is measured by revenue rather than integrity or responsibility for justice. Ethical decision making becomes secondary. Within that culture, the word reconstruction softened what was in truth falsification. This kind of professional language shows how systemic habits can conceal the misconduct. The absence of supervision and proactive regulation means that provisional enablers may not be effectively internalized as part of daily practice. The later LPUL reforms, requiring written cost disclosure and client transparency, were introduced to improve those enablers. In the end, Foreman's moral character determined her conduct. She knowingly created and allowed a falsified document to be used in court. If she admitted the loss of the note, the tribunal might have viewed it as negligence rather than dishonesty. Her continued denial aggravated the finding of professional misconduct. Kirby P's comment captures the essential enabler truthfulness as the foundation of professional trust and the legal system.
I will be presenting the final part of our discussion, which focuses on recommendations for better ethical practice. I will go through three main aspects. Let's start with the law of lawyering. Under ASCR, solicitor admitted in New South Wales bear the duty to act in the best interests of a client, to be honest, not deceive or knowingly or recklessly mislead the court, to correct misleading statement. To maintain ethical standards, solicitors must prioritize honesty over the pursuit of commercial gain. They should maintain detailed and accurate records of their work and cost agreements, and disclose any inconsistencies between these documents to supervising partners or clients, rather than attempting to alter them secretly. Then let's look at how lawyers can recognize and reason through ethical challenges. To strengthen the skills in REST four-component model, law firms could regularly organize ethical workshops and case-based training to enhance the lawyer's awareness of ethical risks in some contexts, such as discovery and cost disputes. They could also incorporate ethical reasoning exercise into professional development programs, allowing lawyers to practice analysis, dilemmas, and balancing commercial pressures with professional duties. This framework strengthens individual moral judgment before misconduct occurs. Finally, let's look at the concept of ethical infrastructure. This case indicates that individual judgment is insufficient to prevent ethical failures. Ethical infrastructure focuses on how law firms can create a supportive environment. Formally, firms should implement structured supervision and file review systems, establish complaint and reporting channels. In management, law firms should appoint an ethics advisor or risk management partner who can provide timely guidance for ethical dilemmas and be accountable for ethical compliance. Culturally, firms should promote open dialogue about ethics and reward integrity over revenue. Together, these systems create an environment that sustains ethical practice and public trust.
Thanks everyone for watching our video. We are Group 5. We really appreciate your time and hope you find it helpful.